Welcome to All Things Social Security. Enjoy your video. Good morning, afternoon, or evening. Stephanie Joy with Joy Disability and All Things Social Security. I wanted to go over really quickly the issue about borderline age policy with the SSA when you are about to hit an age category change. And what I mean by that typically is you're going from 49 to 50 or 54 to 55, and in a very, very minor way, perhaps 59 to 60, but not really so much. Someone was asking about it and when it kicks in. So I'm just going to go through the article and let's see exactly what it says. I thought we did this recently, but I couldn't find it. So I hope it's not too duplicative. So this, by the way, is in the Palms, DI 25015, period, 006, borderline age. So they start with talking about their policy, and that is if a claimant is within a few days, and this is kind of a term of art, a few days to a few months of reaching a higher category, age category, and using their chronological age results in a denial, then after you evaluate all factors, which would include the RFC, age, education, and work experience, then consider using the higher age category if it results in a favorable determination. So that's it in a nutshell. They do point out that if using the chronological real age of the person would result in a partially favorable or fully favorable determination, then only consider the claimant's chronological age. It's only if using his real age would not benefit him. Then you could try to see if it would change using the new age category. And again, that's only if the claimant is within a few days to a few months. They do clarify that, what do we mean by a few days to a few months? They point out specifically that they do not have a more precise programmatic definition for the phrase of a few days to a few months. They say that they'll define the term a few using its ordinary meaning, which means a small number. They go on to say, consider a few days to a few months to mean a period not to exceed 6 months. So while we see a lot where a judge doesn't decide to use it at 4 or 5 months. I think I've seen that. But one could point it out in their brief that, it's an age category change because, in less than 6 months, and then cite to the quotation and cite to the Palms that says it. Then they go on, and this is section C, to helping to identify what would be a borderline age situation. And it is kind of particular. When you evaluate a claimant's ability to adjust to other work, and that's what the grids and the age categories are all about, guys. A borderline age situation exists if, 1, the claimant reached or will reach the next higher age category within a few days to a few months after the date of the adjudication, the date the T2 insured status expired, that would be the DLI, the end of the disabled widower's benefits, and that's if it's a widow situation, or the end of childhood disability benefits re-entitlement period, if that was the kind of program they were in, or if it's a cessation of disability. So in addition to that, it has to be at one of those time periods. There's another requirement, and this is number 2 under C. Both of the following must also be true. Using the claimant's chronological age. You want to say hi? Sorry, somebody wants to say hi. Can you see? Maybe I'll turn you. Sorry, guys. She gets a little funky. Okay, so using the claimant's if the claimant's chronological age results in a not disabled determination. So it can't be where they'd be found disabled in their own rights with their real age. It's got to be when that would not work for them, but would if you consider it borderline. Yeah. Using the next higher category, this is the second part that has to be true. Using the next higher category to adjudicate the borderline period results in a disabled determination. So I think when we look at that, it really does mean, like, let's say it's a 54-year-old, close to 55, but not quite, and they are found able to do light work. They lose in their chronological age category because the grids for 50 to 54 mark you as not disabled if you can do light work. However, at 55, light work renders you disabled. So those are what we're looking at, okay? It's where the exertional most likely would be putting you into a different grid that doesn't allow you to win. So this could be most important, I think, for the 50 to 54-year-olds and the 49-year-olds too. 49.5 plus. They highlight that if you cannot establish all of the requirements, you do not have a borderline age situation, and then you have to use the claimant's chronological age to adjudicate the claim. So going through it again, if the claimant has reached or will reach the next higher category in a short period after the date of adjudication, such as a judge's decision or an adjudicator, or the date that his DLI expired. I'm going to limit it to those two because the rest are about disabled widows and childhood cases and cessation cases. So we're just talking about your regular typical SSD case, or I suppose SSI, date of adjudication or date of their DLI, because as you know, that's the window beyond which the adjudicator or the judge cannot find the first instance of disabled. It has to be before the DLI. And then of course, adding to that, if using their chronological age would find them not disabled, then you have a borderline age situation. And the third thing, if using the next higher category to adjudicate the borderline period results in a disabled. So there has to be, it's weird. It's almost like how the results of using the borderline age rule, if it will help, that's the only way you can use it. If it'll change things. So you almost have to figure it out first before you can figure out if it will apply. Kind of weird. They go on to say, consider the borderline age situation in all situations where age is a factor in the determination of a disability, such as, let me give some examples, prior to expediting step 5 of the vocational assessment. That's can they do other work, where that grid might come into play. When doing a transferability of skills assessment, also very important. And when considering use of the no work or lifetime commitment medical vocational profiles. Those are some more rare rules, the no work and the lifetime commitment, that we won't go into here because they are pretty rare. They give some examples. These are examples that will identify a borderline age situation. The claimant filed a concurrent claim for Title II and Title 16 benefits, that's SSD and SSI. The claimant was 50 years old when they applied, but was 2 months shy of 50 when their Title II insured status expired. Okay, so they have expired DLI. They have an 8th grade education and can no longer do their unskilled past relevant work. The claimant is limited to sedentary work, and Medical Vocational Rule 201.09 directs the finding of disabled at age 50. Remember, so going back to the fact scenario, he was 50 years old when he applied, but his DLI was already expired. It was when he was 49 and 10 months. Can they consider that 49 and 10 months? Can they bump him up to the 50 because it's so close? Bingo. Because otherwise he'd never be able to prevail, right? And he's never going to have an insured status again if he doesn't get back to work at least part-time, which is a totally another topic that, I love to talk about, is disabled people working, particularly if they haven't yet achieved their SSD and they want to get their credits so that they can apply. Story for another day. They also go on to say that Title II, which is again the SSD people, if the Title II claim presents a borderline age situation, consider age mechanically using the claimant's chronological age on the date of their insured status expired under the Medical Vocational Rule 201.18 results in a denial. I don't even get what that just said. The Title II claim presents a borderline age situation. Considering age mechanically, using the claimant's chronological age on the date of they're just explaining what we were just talking about, their insured status expired under the MedVoc Rule 201.18 would result in a denial. That would be the 49 and 10 months. Strict application of the grid, denial. The claimant attained an age that changes the outcome of the decision to an allowance under 201.09 within a few days to a few months after their insured status expired. Although the Title 16 claim is already an allowance, that's SSI, he would win because you don't have to be insured, and therefore does not present a borderline age issue. Enter the Title II established onset date for the Title 16 claim, and they give you a rule to apply that. They say for the majority of concurrent claims, follow existing policy regarding establishing onset in concurrent claims and enter the Title II established onset date for the Title 16 claim. For an exception to this rule, see the details, blah, 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 in this other bulletin. Okay, they're talking there about if the person has SSI and SSD, and SSI doesn't need borderline age, but, well, not in terms of being able to adjudicate it because there is no date less insured. They're saying once you do use it for Title II, use it for Title 16 as well. Another example they give is the claimant is age 51 at adjudication. The claimant has semi-skilled past relevant work at the medium level of exertion with no transferable skills, and their RFC limits them to no more than sedentary work. The claimant has a 12th grade education with no direct entry, which means, i.e., they have not recently completed education or training that provides for direct entry into skilled or semi-skilled work. Medical Vocational Rule 201.14 directs the finding of disabled as of age 50. The representative asks to apply the MedVoc rules non-mechanically and find the claimant disabled 6 months prior to age 50. They say this is not a borderline age situation because a claim would not be denied by using the chronological age. He just wouldn't get it as early. So they're not going to let you use the borderline age movement of the date of alleged onset date a few days to a few months earlier if it only means they're going to win more benefits. If they're already going to win, aka partially favorable, then no, it doesn't apply for that. It's when someone's going to completely lose otherwise. That's what I take from that. Then they have a section about deciding which age category to use in a borderline age situation. They note that in a borderline age situation, do not automatically use the higher age category. Consider their criteria for the MedVoc rules for the claimant's chronological age and the next higher age category. Re-examine the overall impact of all the factors in the case on the claimant's ability to adjust to other work. Begin by analyzing the factors in the case. They go on for a bunch of little details with regard to that, like the period to consider for borderline age. They said, look at the period under review. For example, there may be a few days to a few months between the dates of adjudication and the date the claimant attains 55. And they say that the closer the agent is to the next higher age category, older, the more disadvantageous the claimant's age is to adjusting to other work. They say to consider education for borderline age. Education below the high school level may be vocationally disadvantageous. And they have a big table here. They say that you can use the table in the subsection when considering how the claimant's education relates to the range of education criteria for the higher category. By the way, I'll just throw out some of the details they have in it. If a person is 6th grade maximum education, or is illiterate regardless of formal education attainment. So let's say they graduate high school, but they can't read. Illiterate. That's considered a marginal or less age category. Education category. If they went to the 11th grade, but they are still illiterate, that is considered limited or less of an education category. If they're literate, but only got to the 11th grade, that's limited or less, but literate. That's the age category that falls into. And that's it. Because once you get past 11th grade, you're considered fully educated, like 12th grade or a GED. They note that we need to be careful not to double weigh education. And they give an example of double weighing. Using the education factor to support an allowance if the claimant is illiterate, the chronological age MedVoc rules require the education category illiterate, and the case presents a borderline age situation. This situation only occurs when the chronological age medical vocational rule is 202.16 or 201.23. I don't think I want to get too much in the weeds on these guys because we don't usually have an illiteracy issue, believe it or not. Not generally. I have poor readers, but not totally illiterate. They're just slower. They may not have been great readers when they were younger, or sometimes if we get a little cognitive loss, we might not be able to read as well. But I rarely see a completely illiterate person. They also go on to say, this is interesting, do not reconsider issues such as special education, homeschooling, and possession of a GED certificate as support for use of the higher education category in a borderline situation. Because before determining which MedVoc rule applies, we consider the issue of whether the claimant's actual education level is consistent with their reported years of education. And then they give you a link to some more details on that. But again, that's not really what most of you are asking about. I think it's more about the strict MedVoc, assume we're not illiterate, at what point, and, what are the mechanics of when we can argue for a borderline age category situation, which can be really helpful. We have them here and there. It's not bad. All right, I will stop there. There is more to this though, guys. They give a lot of examples. They give a section on considering past relevant work for the borderline age, but I don't think we want to go there. Consider residual functional capacity for the borderline age. Remember those lists of things we had to look at before? They go into a little bit more example of double weighing and how we don't want to do it. They go into just other overall things that their adjudicators are supposed to do, like determining whether the overall impact of the factors justifies using the higher age category to find the claimant disabled. So despite the fact that there is a rule that allows them to use a borderline age category change, sounds like they've got a bit of discretion on whether or not they're going to do it. So I'd say always make the argument, but realize that it might not be ironclad. They are supposed to document when they do consider a borderline age category though. So I think push them to it gently with honey, not vinegar. And if their analysis of borderline and why they rejected it, if in fact they do, who knows, maybe it'll be something that can be appealable in terms of maybe they didn't rely on substantial evidence, et cetera, et cetera. All right, borderline age category. Hope that helped whoever was asking about it. Talk to you later. Bye.